would get writ petition at page 63. Lords, the prayer at page 75. Lordship got it?
Yes.
Yes. Issue a writ in the nature of certiorari in the bottom, Lords. To quash the impugn notification dated 24/8/23 Annexure J, insofar as selection of PG graduates only without insisting of net/SLET PhD, which is contrary to UGC regulations and guidelines, and directing the respondent number 2 to redo the entire first round of counseling with so. But since by the time this order was passed, Lords, that stage was passed. That academic year was also passed, Lords. The prayer is to stick to the UGC regulations and guidelines and not to prescribe, Lords, any qualification or not to derail or deviate from the UGC regulations. Because what did the state government do, Lords? Lordship, I kindly turn to Annexure J. The typed copy is at page 128.
Yes. Yes.
Because in the bottom, the merit list will be prepared subject-wise for candidates who meet the following criteria. These criteria, while fixing this,
Yes.
they have categorized as general qualification, 25 marks. For that, they have said maximum 25 marks of total percentage secured in their 2 years post-graduation is to be taken into consideration. Like that, they have said. Then, if obtained PhD degree, 12 marks. If NET or KSET or LSET obtained 9 marks. Obtained MPhil degree, 6 marks.
Yes.
In fact, my lords, as per UGC regulations, all these cumulatively is the required qualification. A person should have a post-graduation, then he shall have either the NET qualification, NET exam passed, or equivalent state entrance eligibility test, SLET, he should have passed. And he should also obtain be a PhD holder is the qualification as per UGC regulations. What they have done, they have split it. And my lords, what they have done, they have given time for having additional. In the previous round of litigation, my lords, what had happened, lordship would also get that judgment, which is also part of the writ petition, my lords. At page 202.
Yes.
Very same issue was considered. Then, Lords, in that judgment, to both this issue of giving weightage as well as having a clause, Lord, the clause 6, which was discussed, Lords, which said that though that appointment was made for 10 months, all the candidates were given 3 years' time to acquire UGC regulation. The appointment itself was for 10 months. So that's why it was challenged, and it was, my lords, at page 206, your lordship would get the observation where the court, learned single judge in a previous judgment had discussed.
Yes.
Para 4, my lords, I'll read. However, on the question whether the state government could appoint any person as a guest lecturer without the UGC prescribed qualification, granting time to acquire such qualification within a period of 3 years, and with the stipulation that if such qualification is not acquired within 3 years, there would be no further appointment as guest lecturer. Mr. So-and-so, the Council for UGC, relying upon the regulation 13 of the UGC regulation for minimum qualification for appointment of teachers and other 2018 regulation, my lords, submits that this regulation is categorically that even for appointment of guest lecturers, the minimum educational qualifications prescribed by the UGC must be insisted upon. Regulation 13 is extracted, my lords. I'll not read that, my lords, because it clearly says that the two things it says. One is only 10% of the staff could be appointed through this mode, and they should also have the same qualification which is prescribed for appointing an assistant professor on a regular mode. Then, my lords, paragraph 5, Mr. So-and-so, the learned principal government advocate, cannot dispute that the UGC regulation prevails. And he points out that clause is not part of the subsequent circular dated so-and-so. In the light of this submission and the submissions of Mr. So-and-so, this court must observe that state must consider continuance of the clause lest the impugned clause 6 is cited without application of mind to the prevailing circumstances to accommodate those who do not possess minimum qualification as guest lecturer in terms of UGC regulations. The petitioner's grievance was on weightage. I will not go on that, because that is not an issue here. So this issue regarding even the guest lecturers, so-called guest lecturers, must possess the required qualifications prescribed by UGC is no longer restricted. This order is final. This is not challenged. In fact, state has followed this. But though the state has understood it properly, which is forthcoming in their subsequent deliberations, but they try to forego that and read it in a different way and caused the very same confusion. They did not modify the very same qualifications they prescribed in the subsequent notification. There, as I said, my lords, having a post-graduation in the respective degree in the respective stream with NET or SLET, with PhD, all these together are the minimum qualification for appointment of any person as assistant professor as per UGC regulation. If I may pass on the entire, because the UGC regulation is there in the petition and bits and pieces, hence I thought if the court may permit, I will pass on the entire copy of the regulation, my lords.